You had the last coffee pod, didn't you? You took the last coffee pod.
We're going to go there?
Yeah. You took the last coffee pod.
I was like, what did you do today?
I wasn't able to have coffee thanks to you.
That would be called an evasive answer on my part.
I'm glad when I'm not accused of anything.
Or is it a failure?
We know that you ate the last cookie.
Or is it a failure to deny my allegation?
Right? So we want to talk about,
it's not just a failure.
Is the issue.
It's not just a failure. We're talking about reaction or lack of reaction. This is reaction.
We're talking
about it's two parts.
Yes, we're talking about reaction evidence tonight.
It's reaction evidence, which can be a failure to deny when confronted with an allegation, and two, the demeanor that would be exhibited at the time that a person is facing an allegation.
Right.
So it's reaction evidence.
Right.
And you had a really interesting case recently as well.
One of the only reasons. Well, that's one of the reasons we're talking about this tonight. I'm in the middle of. Well, the trial's almost done. Well, it is done. And one of the issues the Crown's now raising, his submissions, is that during the interchange between the complainant and the accused, she said something along those lines, "You raped me, bro," and he didn't respond to that. He was just like, okay, other topic response was his response, right?
Was this talking on the phone or was
this was text messaging?
So let's be specific so everybody understands. So the accused and the complainant are having messaging back and forth.
Right.
And she says, "You raped me, bro?"
Right.
To which he replies what?
Some other non-related topic. I don't recall at the top of my head what it was.
Like the Leafs won last
night. The Leafs
night.
Won last night, or I really love
in overtime.
You. Or
with Austin Matthews scoring a pretty good goal.
Yeah, or I like your puppy, or whatever, something like that. So total non sequitur, nothing to do with her, what she was throwing
Wasn't
at
there
him.
an issue in here too that the text messages were not complete?
Well, that was my next point I was going to make. This was a very limited amount of text messaging between the two because she had conveniently or otherwise deleted their iMessage history. So this was best of conversations that she provided to the police. Yeah. And it was so, but even more interesting is within the text messages that we did have, there were voice recordings. You know in iMessage when you get that little symbol that there's a, Crown never played those in court.
Right.
And or maybe she didn't provide them, I don't know. But I have them, but it wasn't played in court. And again, incomplete record of the exchange between the two of them. So I was kind of scratching my head.
This is a problem too, because quite often when somebody's charged, they're terrified about accidentally contacting the accused person, the complainant.
Right.
So they'll actually delete and
their own
block
history.
everything.
Right,
they'll delete their own history. And then when the complainant provides cherry-picked messages, then the accused person doesn't actually have the full record because they've deleted it out of fear.
Right. And they were also dealing in the Snapchat world, which, as we know, unless you intentionally save it, poof, it's gone.
Or take a screenshot.
I don't understand Snapchat.
Right. Why not?
It's like people who recreationally take GHB. It's like, what's the point having fun if you forget it?
Yeah, but it automatically deletes, right?
It automatically deletes unless you choose to save.
Change the settings on it.
Yeah.
So let's provide some case law to this, because this is really an interesting topic and we face it quite a few times. So there's a couple of cases out in this year, 2024. One of them is HW. RVHW 2024 ONSC 6471. This is a summary conviction appeal to the Superior Court, and we have to be careful on this one because this was a young person, so we want to be very careful not to disclose particulars. But let me just set this up, and then we'll talk about this in context with what you're facing, what the law is, and then another good case. And there's a lot of stuff to peel back from that.
And this is really important too because quite often people do get confronted with allegations, and so
this is more often than not. So this arises quite often.
How you respond in text can be quite important.
How you respond in text messages, because most people now that we're seeing, it's never by telephone.
People don't talk anymore.
So it's either text message or over some app.
Right.
And then also reaction evidence is an issue. So what the physical demeanor is. And there's a lot of frailties and unreliability about that. So let's just say, so in this case...
And for those of you with young children, you know exactly what we're talking about.
So the trial judge convicted
bonus point.
This young person on a number of grounds, finding that the person was not credible. But one important thing was that the trial judge had reviewed in the reasons texts exchanged between the accused and the complainant post-alleged offense date
Right.
were incriminating in that when confronted with the complainant's allegation of sexual impropriety, the accused failed to deny or correct her allegation, and that amounted to an admission by the accused that the complainant had not consented to the sexual activity.
It's a huge leap.
Yeah. So
Like,
just
seriously?
pause on that one for a
Pause.
second.
Think
okay?
that you might want to repeat that.
No, I'm going to repeat it because
that one's
this is a case that's, the appeal is given in 2024. So I think this was a trial in
Probably 2
the
years
conviction
earlier.
was March of 2023. So
Right.
we're not talking like this is the old days, okay?
The olden days.
The text exchange between the accused and the complainant post-alleged offense date were incriminating in that when confronted with the complainant's allegation of sexual impropriety, HW failed to deny or correct her allegation, and that amounted to an admission by the accused that the complainant had not consented to the sexual activity.
That's a lot.
That is a massive leap.
That's a
And you have
massive
to keep
logical
in mind
leap.
too, you get a message from somebody accusing you of something serious. It's kind of shocking.
Well,
and
it's shocking, and you're like, WTF? I'm not going to lower myself to responding to
Right,
that crap.
yeah.
Basically.
I've got particularly big thumbs. I typo all the time when I'm trying to respond to something, and when you're in a state of like sort of panic or
Upset.
something like that, it's like you can end up sending like multiple messages just like trying to follow up on thoughts or whatever. But yeah, typically you get accused of something like that over text, you just be like, you're thinking what the but what you actually write is basically just panic
Right.
driven.
Often, yeah.
So in this case, one of the elements is that the response by the accused was all you had to say was no.
Right.
Okay. Well, but I can see how that may cause some pause by a judge, but in the context of this case, as in many others, it nowhere gives a foundation for a judge to make this type of finding.
No.
And the judge definitely took this as an adoption of the allegation. In other words, this was an admission, which was quite frightening. So the judge also determined, so this was from the trial judge's reasons. It's important to listen to this for a second.
Right.
The trial judge found that in the circumstances of this case, it was reasonable to expect that the accused responded to the complainant's accusation that she did not say yes, should have called or would have challenged or denied her if what she said was untrue. So the judge applied, it would have been reasonable in the circumstance of this case for the accused to have challenged or denied it.
Right.
That's not the test.
No.
So the test, just to be clear, at paragraph 55,
Yep.
a test for an adoptive admission, and this is for an adoptive admission, okay? It's not just simply a lack of response. I want to be clear on this, okay? The test for an adoptive admission, so that's a higher finding.
Well, adoptive admission by silence,
That's right. But an
Right.
adoptive admission by silence. So, but there can be other circumstances within the messaging. They would not specifically state that it's silence alone. So just by silence is the only reasonable course of action test. That means that there has to be considered other plausible, reasonable explanations as to why the accused responded the way they did or did not respond at all and was silent. So again, it is
So to find it to be an admission by silence, it
That's
has
right.
to be
only reasonable
completely
course of action.
unreasonable course of action to not deny it.
I guess that's one way of putting
It's
it.
the
Yeah.
flip side, yeah.
So this judge made an error of law in this case in applying a much lower threshold. And what was interesting on appeal, which isn't so relevant to our discussion, is that it was framed by the appellate counsel, who I think was also trial counsel,
I think so, yeah.
that this amounted to a misapprehension of evidence because of a slew of issues, which is absolutely true in this case because the judge had misapprehended core pieces of evidence, which included why the accused was responding to certain things. I mean, there was just like a massive...
Well, yeah, and then the Crown didn't even question the accused in this case as to why he didn't correct the complainant.
Okay, so that
That's big.
So that's an important point. So I want you to elaborate on that. So just 1 second. So the judge, this was framed interestingly in a misapprehension of evidence, and the appeal court didn't necessarily agree with framing it that way, but there were so many mistakes by the trial judge on the evidence that whether it was a misapprehension of evidence or was an error of law didn't matter much.
Right.
Now, in order to try and make this argument, either in your case or in this case, what does the Crown have to do?
At least put it to the accused.
Right.
In cross-examination.
Cross-examination, yeah.
Right.
Versus just at the end saying, it's like kind of like the Brown and Dunn concept, right? He didn't put anything to my guy about this. And that's what the court adverts to here.
To clarify, right, so the Crown didn't give the accused person an opportunity to explain why they did or did not respond in a certain way.
Right.
And then in closing submissions,
Is using it against him.
Made the submission that the accused should be found guilty because of a failure to deny without properly asking the accused person why they responded in the way they did.
Right. Yeah.
So this is, again, you can be really sneaky here because you have messages.
Right.
So in this case, like you will see in other cases, a prosecutor can put to an accused, here's the message from the complainant. You raped me, bro. Let's use that.
Let's use that, yeah.
Do you agree that you received this message on October 18, 2024 at 6:42 p.m.?
Right.
Yes, no, I got that message
I got
from
that
you. Yes.
message.
And your response was?
How's the weather?
How's the
out there?
weather? Right.
And you respond at 6:29 p.m. on the same day. Is that correct?
Right.
Yes.
Right.
So you confirmed that that was the message you received and that was the message that you sent.
Right.
Is that enough?
No.
Does that give an accused an opportunity to then expand on why they answered that way? Is that enough to satisfy this test?
Well, the accused can, if it's put to him, yes, he can explain it.
But what doesn't happen, this is why I'm saying it's
You
sneaky.
could get
It's
a little
sneaky.
more clever, like saying, why did you ask about the weather? Right? So that would be a roundabout way of saying, why didn't you deny the sexual assault allegation? Be a little bit roundabout way, but just simply just go through the messages and say, did you send that? Did you send that? Did you send that? And then making closing submissions, the suggestion that, well, clearly he's guilty because he didn't say, are you crazy? I never did that.
So the requirement to apply this test is that the Crown must, in cross-examination of the accused, ask the accused why he or she, whoever it is, did not correct the complainant.
Right.
There is no questioning in this case by the Crown as to why the accused did not correct the complainant. That is a precondition. That's a must.
Yeah. Well, yeah.
I know it seems simple.
It seems simple, but
Like we said, trial judges get it wrong.
as they did here.
And lawyers can get it wrong. Okay, because there's another case we're going to go to, which you'll be, may get it wrong.
But just to point out, though, like, one of the things that came up in your case, too, is that the Crown was relying on a case called Robinson from 2014, which said that you can take this failure to deny into account.
Right.
But that, obviously the cases we're talking about are more recent.
More recent, yeah.
Right? And, it happens quite often that these historic cases that get brought up in court have very specific circumstances that are unique to that particular case.
Right. There are some scenarios.
And then they get used, just like JJRD.
Right.
We've talked about a lot, where you can convict somebody even though their evidence was believable or whatever. JJRD had specific circumstances where there was corroborating evidence and so on. Same thing with Robinson, where there's specific circumstances to a case. And this is what makes it really difficult when you're compiling case law, I think, to go into court and understanding what that case law means and how we argue it and why it's important to know what these cases are, right? So they reference, in this case, they reference Robinson.
Right.
And they say it doesn't apply here.
Well, explain what Robinson says then.
I don't actually have that one printed out.
Okay. Well, I'll go through it in a moment, but let's just cap for everybody, because it's an important point. So in order to get an admission by silence, the Crown must ask in cross-examination why you did not correct or say something in response to that. It has to be a specific directed question.
Yes.
I know I'm repeating myself.
No,
but it's important.
No, but also I want to point out, too, that there is a bit of a problem with this in that the original accusation on text messages
Right.
essentially amounts to a prior consistent statement by the complainant. the fact that they accused the person contemporaneously of something doesn't make it more or less likely to be true. And that's a factor that needs to be addressed as well.
Right.
Just simply the fact that the accusation was made doesn't make it more likely to be true.
Right. But we know that.
Right. Just expanding on it.
I know, but it bears a lot of repeating, because this is an issue that rears its head quite a few times, and we will find cross-examination in cases where the accused are not directly asked critical pieces of evidence.
But you have to scratch your head and say, this is so basic and obvious, why aren't the questions being asked, right? Like it's so easy to tick off.
Well, here's the thing. So when you have messages, and you may have not just one or two messages, you may have, let's say, like we have multiple messages.
Pages sometimes.
So a Crown can go through multiple series of messages but not interject the appropriate question at the right time. And that's an issue. And then you also have to look at the series of questions, because the Crown might try and argue, well, I did confront him with it, and it's not true.
It's not true, right.
It's just, and I'm not imputing, malice or anything on a Crown attorney who does that, but I'm saying it is a precondition in order to make this finding that you ask this question, and you got to be very specific and clear about it.
If you're going to make the specific allegation in your submissions, then you got to make the specific confrontation in your cross.
Absolutely.
You can't just go through, weren't these your messages back and forth? Yes, they were, and then you just leave it, and then you can't just use it against the person later. That's just ridiculous. That's why I scratched my head when I got the Crown's late additional submission saying, what are you talking about?
So the other issue with your case, and we'll cover the other Court of Appeal decision in a moment,
yes,
is that you have a selection of messages that are not a complete record of the messages. In other words, it's not a seamless thread
Absolutely
of
not.
messages
You see
between
gaps
them.
in what's being said.
Well, the gaps are admitted. The complainant admitted, yeah, I deleted our iMessages. I didn't save Snapchat. And so how is it that you came to only selectively present these to the police when you were being investigated, right? So no, it was a total select. And the audio messages are not transcribed. There's no audio messages. So it's a pick and choose screenshot scenario. So she picked the ones that were obviously most favorable, where I think she knew what she was doing. Like, she knew, I'm talking about rape here and he's not responding, so this is going to look good. I really think.
Right. So, but this is a really important point, because a person can be set up by the other person. And you can imagine how confusing it is if these messages are not the next day, but not the next week, but they're months later, which we've seen.
These were 7 months later.
So let's explain this a little bit more. So, because we see this all the time. So the messages come 7 months after the alleged date of the sexual assault.
Right.
They're cherry-picked by the complainant.
Completely.
It's admitted that it's not a complete record.
Right.
And it's being used to try and have an admission.
Not fair.
Not fair. And in your case, I think it's going to be a fairly easy argument to the trial judge to say, you can't make that finding. No. And the very nature of the fact that this is not a complete record of messages affects the weight, meaning how much,
what's the value of it?
What's the value of these messages? Right. But that's the trickery here, because we talk about this so much in the podcast that whenever we're faced with messages from a complainant, it is a rarity to get a proper thread. It's a rarity. It just doesn't happen.
No, bits and pieces, often missing.
And so in many respects and if there's a failure on top of that to put to an accused why they didn't say X or Y or Z or do whatever, it's incredible mischief. It's just completely wrong in law to try and get that finding by a trial judge.
Yeah, it's not fair.
So one of the comparisons, we're going to move on to the Court of Appeal case.
Just one thing. So you talked about Robinson. Robinson is essentially one of the cases that properly said the test is that in order to make a finding, in all the circumstances, a denial by the appellant would have to have been the only reasonable course of action expected if he was not responsible. So I just want to close the loop on that, and that is
well done.
2014 ONCA 63.
Total loop closure.
Okay, so I think we should move on to the Court of Appeal case and talk a lot about it, because my jaw dropped on some of this.
Yeah.
I hadn't.
Yeah, it was kind of scary.
One of the things to talk about in here too is just thinking about real-time reactions on text messages or whatever. It was approached as being a consideration of demeanor, right? So demeanor is an interesting issue, I think, in court as well, because when somebody testifies, there may be a lot of
interesting
reasons.
point.
There may be a lot of reasons why they may seem fidgety or evasive or whatever, because testifying can be quite scary for a lot of people. They're not used to doing it. And especially when you're the accused person, you realize your life is on the line. And so a lot of nerves will kick in.
So you're
and then
talking
also,
about another layer now.
Yeah, and then also complainants
Text
complainants
demeanor.
may cry, right? And some people can cry on cue when some people are crying legitimately. But so demeanor has a value in terms of credibility assessment, but it can't be, definitive.
Now, are you
right?
talking about demeanor while in court testifying?
No, she's talking about written demeanor now.
So,
I think, right?
so the same principles apply to the way people respond on text, and we know notoriously text messages. There's a whole case that we've used before too, talking about how, emotions aren't conveyed properly in text messages.
Tell me about it.
We use emoticons and things like that to try and punctuate and try to
I think we call
convey
them emojis
emotions.
now. Emoticons is very 2000.
Emoticons,
I prefer emoticons.
You really?
I like that, yeah.
That sounds cool,
It
but
seems very technical. I
it,
like
does,
it.
it really does. The emoticon in this case.
But it's
was-
really easy to be misunderstood over text messages.
Yes.
And, so demeanor in terms of written messages,
demeanor.
although
Yeah.
you've argued quite often, like these are real-time messages. Text messages can be very compelling in terms of how we
It
use
is.
them. But at the same time, we need to keep in mind that, when you're receiving a text message, you don't even know if the person's at work when they got the text message, right? Why did it take you 2 hours to respond? Because I didn't even see it,
Right. No, but I think, there's a difference. When we rely on
2
a
hours.
series of messages, when I rely on a series of messages and I argue that this is real time, evidence of how they're interacting and what their dynamic is, I'm referring to something that happens to be non-confrontational sometimes. A lot of it is refuting a narrative by the complainant, where the complainant, for example, says, "Oh, I didn't want to go to his house. I was scared of him and I didn't want to go over, and we'd broken up." And the messages are like, "Oh, when can I come over and have sex with you?" So it's like when you have that back and forth, that's a real-time, authentic exchange of what was the true dynamic, contrary to what the complainant's saying. But when somebody is faced with an accusation, it's a bit of a different circumstance, especially if it's months or years later.
Right.
And that occurs. So, the case of
There's no good emoticon for that.
His Majesty the King versus DB is another excellent case. Court of Appeal 2024 ONCA 546. It's a very interesting case of historical sexual
It's
offenses.
a scary case.
It's interesting because the Crown's cross-examination, and this was in front of a jury. So the accused was convicted of 3 historical sexual offenses against the complainant, his niece, when she was between the ages of 6 and 10. He was convicted of 1 count of sexual assault and 1 of sexual interference and 1 of sexual touching. And there are several grounds of appeal, but what we want to focus on is
The reaction evidence.
the reaction evidence, and then what was cross-examination by the Crown of the accused when testifying about this whole scope of reaction evidence. But let's just say one thing, and I'm going to turn it over to you to talk about this for a moment, okay? Because I talk too much.
No, you don't.
Let's first I just want to talk about demeanor, because you raised an important point. So a person's physical demeanor.
Thank you.
No, but it's an
We're
important
not
one.
talking about your makeup.
Their physical demeanor at the time that they're confronted with an allegation,
Right.
in and of itself, is notoriously unreliable
Right.
and recognized by the courts in that regard.
Right.
There are many reasons, and you've heard evidence, like umpteen times. Well, when you accused, Mr. Y about this, how did they appear to you? Completely calm.
Right.
Well, what the does that mean,
Not much.
right? But we've seen stuff like that be used against an accused. So let's just be clear. The actual demeanor presentation of a person when confronted with an allegation is inherently unreliable and fraught with discriminatory beliefs and presumptions about how a normal person would behave when confronted with an allegation. That also applies similarly to why they may respond in a certain way to an allegation by messaging or on a phone. But I just want to start off with that premise about demeanor. Okay, go ahead.
Well, no, I was going to kind of continue along those lines, that the poor accused just withered in cross-examination when he was confronted with this by the Crown. So this is page 6. This is part of the cross-examination, and I just feel sorry for the accused here. I'm going to suggest to you, sir, that if you were innocent, if you had nothing to hide, you'd want to resolve this huge accusation that's made against you. And the poor accused starts falling apart, and, well, maybe... I'm going to suggest to you, if you had nothing to hide, and that if you didn't do these terrible things, you'd want to address it with the family to get to the bottom of where this was coming from. Well, maybe I should have. Like, the poor guy just fell apart.
Well, but actually, the answer in and of itself was a reasonable answer.
The answer in itself, yes.
But let's set this up a little bit more, because just so everybody understands, this is really... So, not the complainant, but another person, years later, calls the accused over the phone and confronts the accused with the allegation.
Right.
That person is called by the prosecution to testify. And the Crown...
I think it was the mother of the complainant.
Whatever. I want to be careful not to identify him, but I think it is the mother.
Right.
The Crown objected to GB, which is the mother, testifying about the appellant's responses during the conversation and only asked her questions about what she told the appellant. The Crown also objected to defense counsel leading evidence during GB's cross-examination that the appellant had denied the allegations. So all that was not allowed because of whatever. The appellant testified himself in evidence that he was devastated by the allegations. My heart was pounding through my chest. I was thinking a million things in my head, trying to figure out how this happened. And in cross-examination, the appellant testified that he was scared and really upset by the allegations. According to the appellant, GB told him not to contact her again, and he took no further steps to contact GB or the complainant about the allegations. Right. Now, it is really important when you talked about the cross-examination, I think we need to spell it out here, just so everybody gets this, because this is the type of shit that can lead to a wrongful conviction.
Right.
This is in front of a f***ing jury, okay? So juries are normal human beings who, are going to go, yeah, that makes sense. Why didn't you f***ing do that?
And they also don't particularly know...
Why did you do that?
Also don't particularly know the rules of evidence. They don't know what they weren't allowed to hear.
Do Canadians sound like that? Yeah. Sorry.
North of Bloor Street.
Yeah. Why didn't you f***ing do that?
I had no idea until I listened to myself on video how I say house, like the Canadian stuff like that.
Oh, really?
Yeah, I never recognized my accent until I listened to myself.
I don't know if I have an accent.
And along the lines of this being a jury, look what the judge says to the jury in the charge.
You're jumping too far ahead.
I know, but it's exciting.
Just don't. We need to set this up.
Okay.
Just like a cliffhanger in
All right. I'll calm down. Where's my calming
what was that
blanket?
series that I just couldn't stand? Marcy made me watch.
What?
Describe.
It was on Netflix. There was 2 of them.
There's several. That
At least it wasn't a Hallmark movie.
No, it was Hallmark with murder. Oh my God, The Hotel.
Oh, the hotel one. Yeah, I know the one you mean.
Anyways, there was always a cliffhanger in there, so let's set it up.
Right.
Okay, do the
It really drove me
cliffhanger.
nuts.
Well,
The White Lotus.
The White Lotus.
Oh, thank God, my
You didn't
dementia
like
moment's
that.
over.
I
didn't really love it that much.
I loved it.
I liked the characters in it because they were
characters
pretty
are great.
entertaining.
Yes.
But it was just like too much for me.
It's so funny how criminal lawyers don't actually like watching movies about crime, though.
I never do. It's funny. I
agree.
You heard I was being interviewed on radio, and it was about something, and then they asked me, "So, what do you do to relax? Like, do you watch these things to relax?"
John Wick.
John Wick.
James Bond.
No,
right.
but you also love the octopus movie.
The Octopus
yeah, I do.
movie? Oh, yeah.
Yeah. That was heartbreaking, frankly, because
I didn't get it. I watched it. I didn't get it.
we're so off
So,
topic.
I know.
But there's this
Okay.
great
We'll get
documentary
back.
about this guy who's diving. He goes back to live in South Africa, and it's an octopus, and they're very bright. And it was just it broke my heart when I watched it.
I
Okay,
know.
so let's set this up. We've done enough. People are already tuning out. They've already gone on to like something
Okay,
else.
so paragraph
set it up.
24.
Cross-examination. Let's go to paragraph. Let's go to paragraph
Pick a paragraph.
15.
Oh, okay, you're still ahead of me. I'll wait until you get to 24.
Oh, no, that's a good paragraph. As paragraphs go. This is the cross-examination.
Go. We need to do it. We need to do it. I know we run long on these, but we just got to
Okay, we're
do
going
it.
to do it again? Are we doing it again?
Just do it.
Okay, can you be the accused?
We're on paragraph 15.
We're on page 6.
Oh my God, you're
paragraph
taking too
15.
long.
Okay, I'm going to
I'll
suggest
catch
to you,
up.
sir. She will. I'm going to suggest to you, sir, that if you were so innocent, if you had nothing to hide, you'd want to resolve this huge accusation that's been made against you. Top of page 7.
What?
The answer is maybe.
Maybe.
Okay, and I'm going to suggest to you, if you had nothing to hide, and if you didn't do these terrible things, you'd want to address it with the family to get to the bottom of where this nonsense was coming from.
Maybe I should have.
Thank you.
So the theme of getting to the bottom of it featured prominently
Everywhere
in
in
the
the
Crown's
closing address.
That was Oscar
cross-examination
ready. That
and
was
in
Oscar
closing
ready.
address. And what I think was also set up, which isn't carefully spelled out, was that the accused was, a relation, and therefore that also would have been a factor in wanting to get to the bottom of this.
Of course,
this was his
family.
Yeah,
Yes,
family.
yes.
So this was, I'm not saying this wasn't a creative cross-examination, but you can see the prejudice that comes with this and the mischief that comes with this if this is not handled correctly by the court.
Which is reaffirmed by the judge. We'll get to that, I know.
It's kind of interesting in paragraph 17, actually, the way the Crown...
Don't repeat that yet, because I tried to jump
So we're at
there.
paragraph 16. So
We're
we
still
now
at 16.
talk about the closing address to the jury, because this is really...
Who, me?
Yeah, 16.
Yeah,
I'm
I
trying to
know.
give you time to talk.
Oh, yes. Cool. So the Crown's closing address, it was, as you said, the total theme was getting to the bottom of it. So the Crown said in her closing, the most obvious example of the accused evidence not making sense is his testimony about how he behaved after the mother confronted him about touching her daughter. As you heard, mother's confrontation of the appellants was pretty intense. So intense that on his evidence, in his own words, it left him devastated, thinking of a million things, heart pounding through his chest, and he was scared. He was accused of sexually assaulting a young child, his own niece, his brother's daughter. But after the accusation was made, he never did anything or said anything about it. And then it gets worse.
Yep.
So imagine a Crown standing in front of the jurors.
Hang on, you missed page 8.
Yeah, I'm getting there.
Okay, good, because this is a doozy.
This is a doozy. Okay, I'll stop shaking my head. Doesn't common sense tell you, ladies and gentlemen of the jury, that having been accused of sexually corrupting your young niece, if he were so innocent, he would want to sit down and talk to his brother, his niece, or the mother to figure out where this was coming from, to clear this up, to clear his name if what she was saying was not true. Or at least, if he were innocent, he might want to talk it through to put everyone else's mind at ease, given how serious these accusations were. But he didn't seek to do any of these things. Can you imagine 12 jurors listening to this? They go, uh-huh.
And then the trial judge stepped on this pile of shit and kept going with it.
No, the trial judge puts a ribbon on this gift.
They repeated this line of reasoning.
So I'm the judge now. Crown's finished.
Can I be
Defense
the
is
judge?
finished. Okay, be the judge, but talk in a manly voice.
So a judge is allowed, let's just be clear, in a jury case to put positions from the defense and the Crown to the jury. So go ahead, Diana.
Your Honor.
Trial judge's charge repeated the Crown's position, and he said, if he were innocent, it does not make sense that he would do absolutely nothing after being accused of horrific criminal allegations involving the sexual corruption of his own niece. Rather, his actions is in line with someone who's ashamed of what they had done.
Oh my God, that's so bad.
So this is an instruction given to the jury by the judge.
That is so cringe.
It's not an instruction. This is where I want to be careful. Right. This isn't an instruction. No. This is the judge simply repeating
the judge's charge.
a portion of the Crown's argument.
Reiterating the arguments.
So a judge, what we typically do is we'll send a summary of our position to a judge, and if the judge, they can rewrite it a bit, but they generally read it into their charge to the jury. Right. So this was part of the Crown's position, but it was reiterated, and when it comes from a judge, it has a little bit more, oomph to it, right?
Validity, yeah. And problem is, the defense counsel did not object to the Crown's cross on this, so that almost, kind of underscored it.
Yeah, but in the course of a trial, it's
and having heard this, and again, not a criticism of defense counsel, but defense counsel did not ask for any sort of limiting instruction or correction from the trial judge, which would have helped.
So you can imagine now just how damaging that line of cross-examination is.
Total.
And
He's not even being accused anymore of having done the thing so much as he's being accused of
not saying anything.
Yeah.
of not
He's being
denying
convicted
it.
of not denying.
He's being convicted for literally not denying it and not trying to take steps to correct this with the family or whatever it is. It's very serious. So again, the Court of Appeal very clearly says evidence of their demeanor when confronted with an allegation is notoriously unreliable, and it extends to a phone call or to messaging as well. These types of situations, the evidence can be highly suspect, and it ought to be admitted at a criminal trial with caution. This is because perceptions of guilt based on demeanor are likely to depend on highly subjective impressions that may be difficult to convey to a jury, and in any event, the significance of the reaction will often be equivocal. Such evidence is predicated on an often unreliable assumption about how a normal person would react to a highly stressful and unusual situation, and because it assumes that outward appearances accurately reflect an individual's state of mind, and then this is also extended to how they will then talk about or answer certain things. So this is really important.
Well, it's funny because I just was doing a client meeting today preparing for trial, and he said, I'm normally a very quiet person and I don't get aggressive, and I'm worried that my ex, who's going to testify against me, she's very loud and very assertive, and that she's going to convince the judge simply through her theatrics. I said, well, we'll deal with that issue, but no. And that's what they talk about here. They talk about the Levert case from the Court of Appeal.
But the court notes, they extended the principle from Levert to an accused failure to deny an allegation because, like demeanor evidence, the relevance of the accused failure to deny rests on an unreliable assumption what a normal reaction looks like. Same type of concept.
Exactly. What's normal?
And it's so interesting because there's such a big deal made about how complainants can't be expected to react in a particular way.
Right.
Thank you for bringing that up.
Yeah.
Right.
Round of applause.
We've got this whole
So
thing
how
is
come
like,
accused have to be-
any reaction is consistent with being assaulted or sexually
Right.
assaulted.
Yeah.
But when you're the accused person, apparently you're expected to only react in one particular way.
That's right.
I think most courts understand this.
Yes.
We make sure we deal with this, okay? Like, there's no way we let this slip by, right? This is not going to slip by.
Yeah.
But this is a recent case. This is two recent
cases. The issue's still arising, which is the scary part.
So kind of find it interesting, like in defending like the conviction on this appeal case, that the Crown was arguing that we weren't arguing that his reaction or failure to react was the impermissible reasoning that it made him look more like
Right.
it didn't accord with that of an innocent person. They argued that it was just a contradictory evidence in terms of him claiming that he was devastated when he heard it. And he said, well, if you were devastated, then you should have reacted like you were devastated.
Right. The Crown.
So that was their defense of the conviction, trying to uphold the conviction.
Yeah. The way they spun this was that the line of cross-examination wasn't to say that his lack of doing something or responding was an admission, but his claim that he was so devastated was incongruent with him doing nothing. Therefore, but the Court of Appeal says no fucking way. This is we clearly know where you're going with this and just how dangerous it was. I want to be clear on the law, though, so everybody understands. There are circumstances where an accused can be taken as having implicitly adopted an accusation as true based on their conduct or demeanor, or even based on their silence in circumstances that give rise to a reasonable expectation of a reply, and that is that it would have been the only circumstance. And there's many murder cases that this happens, right?
Right.
And there's a good example where a friend of a victim and the appellant asked the appellant over the phone why he had not attended the victim's funeral, and told the appellant that she had heard he was the one who killed the victim. The appellant responded, "Shut up, shut up, shut up. This is not a conversation to be had on the phone." Yeah, well,
yeah.
So I don't want to say, I want to be clear that on the law there can be circumstances, and that's why the test is the way it is.
Right.
But this is a different circumstance.
Right.
And,
Yeah,
and
no,
this is-
the court says that the Crown is not absolutely prohibited from leading evidence of an accused demeanor reaction when confronted with an allegation. There are exceptions.
Yeah, so I think overall, I mean, the court notes evidence about the accused's demeanor, evidence of an accused's actions or inactions after being confronted with an allegation or difficult news may be relevant to a live issue in the case and more probative than prejudicial. However, it must be approached with caution. Ultimately, it'll be up to the trial judge to determine with vigilance to look out for this type of evidence and exercise their gatekeeping role, blah, blah, blah. That's a nice way of saying you got to be really careful with this evidence because it's highly suspicious. And in this case, it was clear that what the Crown was doing, and it went way over the bounds of what was appropriate. And the trial judge, at the very least, frankly, should have given an instruction to the jury.
Curative.
But I would have objected in that line of questioning and said,
To begin with,
to say that's not appropriate. This is not appropriate questioning.
Well, they kind of summarize the stuff that we've been talking about too, at paragraph 26, saying, in this particular case, there was nothing internally contradictory about the appellant's evidence concerning his reaction to the allegations and his failure to contact the complainant or her mother after the phone call. The respondent's submission, rests on, which is the Crown's submission, rests on the flawed presumption that an innocent person in the accused, or the appellant's shoes, was required to do something after he was confronted with the allegation. And, his evidence was clear. He testified he was trying to process why the allegations are being made.
And
it wasn't required.
Read the next sentence, though. It's simple, because you alluded to this earlier.
Fairly read, the accused's position was that he was in a state of turmoil, and respectfully, his subsequent inaction did not reveal an internal contradiction in that
So it's
testimony.
like you said, you get this text message, you raped me, bro. So you're processing that. You don't have to immediately say, no, I didn't. It's like, what? You're processing it.
You might just say, hey, how you been? Haven't heard from you for 7 months.
Yeah. And good for the Court of Appeal.
Yeah.
And they said the Crown did not use this evidence for the purpose of contradicting the appellant's own evidence. Instead, the Crown argued that the appellant was guilty because if he had been innocent, he would have inquired with the complainant or parents about the accusations. And this was argued as guilt.
Yeah.
The inaction or failure to address the allegation with the complainant or her family was a central plank of the Crown's cross-examination of the appellant and its closing argument. And it was very clear it was the inaction which was amounting to an admission of guilt, and the court was correct to say that this is wrong.
Yeah.
Yeah. But it just kind of goes to underline, like we've talked about before, in terms of don't talk to the police, don't make statements, until you're properly advised by a lawyer. But we've also mentioned before, text messaging now is there's people who text message so much, I actually don't even know how they work because they're on their phones.
Yeah, relationships. We were
sending out
finding
these
now
messages all day long, and it's just but what you put in writing is so important.
Yeah, but people don't realize that.
At the time, you have to be a lawyer who's then litigated hundreds and hundreds and hundreds of these cases like we have in order to be a person at the time going, I think this could be read in a certain specific way.
This
emoticon,
yeah.
Because the Court of Appeal says this, and this is, absolutely true. It's because inferences are predicated on unreliable assumptions about what an innocent person would do in circumstances like this. It's just wrong. You cannot assume, just like we can't assume how a real victim of abuse will behave, you can't assume how an innocent person, a real innocent person, would behave in these circumstances. There can be a myriad for reasons, and that's why the test is so stringent, that in order to have an admission by silence, it has to be the only inference that you can draw in the circumstances. It's got to be so stark.
Black and white, otherwise, no.
And in sex assault cases, given the dynamic of a relationship or whatever and the timing of the allegation, it's hard for me to imagine where you would have such certainty.
Right.
I'm sure we could come up with a fact scenario, but anyways, this is interesting.
People are not one-dimensional, right?
But it's also really important, too, for people to understand how complicated these cases are in terms of defending and the arguments that you face when you go to court. That is these are not straightforward things, like the nuances of the arguments being made by the Crown and, the ability to defend against such arguments takes a lot of practice and a lot of expertise.
Yeah. I mean, yeah. I mean, it's just like,
That's just a big.
You
yeah,
have to be
Diana.
alert to so many issues, and you have to be thinking about it ahead of time. You've got to really be very careful in the analysis. You know, there's a lot involved in this, and the slightest, especially in front of a jury, the slightest missing
jury,
of something.
That's terrifying.
It's you know, it's dangerous.
Could be damning. Yeah.
And you know, when we think about now, I got to tell you, it's funny how we've come full circle on this so much. As much as the new legislation still bothers us and does aggravate us in certain circumstances, at least as defense lawyers, and if any are watching this, you're forced when you have to bring an application ahead of time to think about these issues months and months in advance. Because if you've got messages that you want to get in, or you know the Crown has messages and you've got to put in some 276 evidence, meaning other sexual history evidence or some messages, you're forced to think about this carefully. And that's why we've erred on the side of a very, very detailed application and very detailed affidavit. You're literally going through all of the three-dimensional chess ahead of time.
Yeah. And that's a good thing usually.
And also having to predict that the Crown's going to use everything they've put in disclosure.
You're right. Well, you have to assume that these days.
All right. That was a big topic.
That was a big
How long did
topic.
we run on this one?
Almost 50 minutes.
Oh my God,
wow.
we're running long these days. So,
That was good.
well, to a good week.
Yes.
Good luck on that case.
Yeah.
Yes, thank you. It'll be interesting.
I'm too tired. I can't lean forward that much. All right, good night,
I'll do it
everybody.
for him.
Thank you
Here.
very
Don't
much.
forget to like, subscribe,
Get the
leave
Share.
comments.
You should
share.
Pick the pillow. Though.
It's okay. We don't have to do pillow talk.
Diana
but,
always does pillow talk.
Keep coming up with the
Apparently I
questions
don't
and
probably.
comments because they're very helpful.
I understand.
Good night, everybody.
Good
Thank you.
night. Thank you.